Hello, guys. Hope you're doing well amidst all the coronavirus outbreak going on around the world, and hopefully you are spending your free time fruitfully, working on your skills, and of course gaining some knowledge. I'm not sure how many of you have joined the stream. If you can write in a live chat, so I know and have understanding how many people have joined the class. So to have a feeling of people joining. I can say at least 10, but let's see and wait. It will be going to be a bit weird, I think, class going well. Seeing some folks, that's good. Hi, Nazreen, and I hope the rest are also joining, and will be not only just showing up numbers, but really actually listening. I don't think we'll take too much time today, as the first time we're trying to do the online and distance learning class, at least for me. Probably you've already have some classes on that. Can you hear me well, or should I connect the microphone? No, yes, any ideas? Okay, there's no reply from you in terms of whether you can hear me well or not. I will start streaming, and if you feel that you need anything to change, or you think that if you need a microphone, please let me know, and I will just start talking to microphone. But so far, I'm thinking just everything is okay. So let's start. We haven't seen each other for a while, but now we can see me, but not otherwise. But still, I'm really glad that you're joining for the class and you're spending your time fruitfully. So as I first remember last time in our last class, we stopped, we just have a general overview and brief introduction in terms of what we're going to study during the class, but not really going into the details in terms of, okay, what's the specific topics. So we'll start from the first one in terms of legal entities. We have covered it partially and going through it in terms of what types of the legal entities we have in Azerbaijan, as well as we have discussed that we'll be primarily concentrating on joint stock companies and limited liability companies, which are two most common forms used in Azerbaijan, rather than talking about additional liability companies or partnerships, but the partnerships which are determined in our civil code of Azerbaijan, not the ones which are globally accepted. So yes, as I've promised, we'll be starting with legal entities in terms of establishing of legal entities. I guess you have covered it probably within your civil code, civil law class. So if you see I'm going being repetitive, please let me know, but this introduction we need to make. So of course, in order to any legal entity to start functioning, you need to register it. Also, in some legislations, if we compare and take not only Azerbaijan, but other countries, there are some countries which allow to legal entity to function without being actually registered. They just create and conclude agreement between the shareholders and within us for the legal entity to work and to operate. But in Azerbaijan, in order to legal entity to function and to be called a legal entity, you need actually to register your legal entity. And for that, there are certain procedures. It's not covered within the civil code of Azerbaijan, but civil code provides you general reference to other legislative acts. So legislative act actually regulating registration, liquidation, amendment of registration details of legal entities. This is actually what's going to cover today. It's regulated by the law of Azerbaijan on state registration of legal entities and state register. Hüquqi şəxslərin dövlət qeydiyyatı və dövlət reyestri haqqı qanunu. So if you want to see like how you should follow the process, which types of documents should be submitted, what are the time frame for submission, you should go to this law and to review what's in it. But basically speaking, if you need to register, it's quite easier to register legal entity in Azerbaijan. It's quite difficult to liquidate it, but registration is one of the easiest in the world, I would even say, because it takes you generally like 2-3 days once you have all the package of the documents prepared. There are some practical matters which you need to consider. We're going to come to them soon, but As a first step, what you need to do once you decide to have a legal entity, it's of course to prepare an application, which is called ADISA. And this application differs, it's a little bit depending on who is a founder of the legal entity, whether it's a physical person or legal entity. The types of information you need to provide for this. For instance, your legal entity wanted to register another legal entity, which will be your subsidiary or your dependent company, you will need also to provide your own legal documents along with the application, and of course to note it in the application. In Azerbaijan, there's a two registration body for the legal entity. Yes, so I'm back. Just side note, if you see anything like going slowing streaming, as a lot of people are now at work, at home, a lot of internet connecting providers are slowing down the internet. Hopefully we're not gonna face any issues on that. So yes, there's a two registering body in Azerbaijan. One of them is Ministry of Justice, and another is the Ministry of Tax of Azerbaijan Republic. Ministry of Justice is for the non-commercial legal entities, whilst Ministry of Taxes is for commercial legal entities. The one thing we didn't mention in our last class, besides having a commercial and non-commercial legal entities in Azerbaijan, we also have a public legal entities, which are a bit different. Again, we're not going to spend much time on that because this specific entities created with specific society functions, which have like anything, some function of the state. So it's not like some common entity you're gonna go and register or you're gonna operate. So yes, getting past the registration body. So in Azerbaijan, you have two registration bodies. One is the Ministry of Justice, which is responsible for registration of non-commercial legal entities. Another one is Ministry of Taxes. When I'm thinking that it's quite easy to register legal entities in Azerbaijan, I refer to the commercial legal entities because it's quite easy in live stream process and everything is set up within the Ministry of Taxes. But when you want to register non-commercial legal entity, it's going to be not a disaster, but somehow yes, because it's a burdensome procedures. It requires a lot of documents collections and submission, and then it takes you at least, I guess, 1 month to wait for registration. At least that's what's happening from my own experience when we have tried to register legal entities, which are non-commercial legal entities. There was a lot of documentation required, and there's always going back and forth explaining why you need these documents, why you want it to be registered, what functions you're going to do. You have to have a specific purpose. So it's quite burdensome. Unlike this procedure, registration with Ministry of Taxes and commercial legal entities is quite easy in this regard. So you basically provide application, and besides application, you have a list of the required documents, which are, I guess, in Article 5, you can see of the law that I've referred about state registration of legal entities, which will include also providing charter of the legal entity you want to register. And in the charter, you need to write some brief information about founders, legal address of the entity where it's going to be registered, provide its functions, obligations, liabilities, what's entitled to, information about its governing bodies, and so on. So the basic information which are needed to legal entity to start operating or defining its function and rights. So this is going to be reflected in the charter, and of course, charter capital, amount of the charter capital, any amendments to the charter of the company, how it will be done, and so on. So this information is being reflected in a charter of the company. One thing to mention here that I have witnessed during my practice in terms of registration of legal entities, when you want to have some non-standard charter, I mean, usually in Azerbaijan, even if you go to the Ministry of Taxes, you will see that they have a kind of a standardized charter document. And when you bring your own charter, they always, take and compare it one to another to see how their standard charter is different from the one you have providing. And if it's completely different, for instance, if there's a directors and you say, I want to appoint 3 or 4 directors, or I want to divide the functions in this matter, which is different from the common practice in Azerbaijan, you're going to face some questions. And it's quite often happens, they say like, why you want to have it? Better, to go back and have this standardized form, or let's do it in that way. to have it too general, not to be too specific that you want to have in your charter, and so on. We have witnessed it several times, and we have actually need to explain to the representative at Minister of Taxes, no, this actually charter we want to have. This is type of the management we want to have, and we don't want to have a common practice. So, and they start arguing and hesitating to accept the documents. But if you're firm in your decisions, then they will have no other option to accept it, unless they will tell you that it's unlawful or you can't do it. But quite often you can, but they just don't want to have something uncommon and unusual for them. So if you're registering the company, just know your rights, know what's allowed under the legislation, and go for it. So this comes in terms of registration. When you're registering non-commercial entities, once you have submitted the whole package of the documents, it will take them 2 days to register you, 2 or 3 days. And even if you want to go even faster, they also provide services for electronic registration of legal entities, which even takes 1 day once you have submitted all the package of the documents. Another thing to mention here is about signing of the application. So when you talk about the signing of the application, it should be signed by the authorized representative of the entity. What happens here, when you have a local entity, this is actually not that much a problem, or local founders, it's not a problem in terms of going to the Minister of Taxes office and signing as a document of their presence, or notarizing the document, because it's another option. When you don't put a stamp or you don't sign, you have another person which will notary certify that is actually allowed to register it. What happens there is that when you have a foreign entity coming, or foreign founders, and if they're not coming physically to Azerbaijan, that's where you can also face some challenge. Actually, that's happened, for instance, for us with our international clients when we're representing them, because all the documents executed need to be submitted to the Ministry of Taxes within 10-15 days from the date of their signature. It's 15 days, if I'm not mistaken. So the time starts ticking once they have been executed or once they have been apostilled. Because if you know that about this apostille and legalization of the documents, if any of the documents are executed abroad, in order for them to be recognized in Azerbaijan, they need to be legalized, which means legalization is quite of, it's not an easier, let's say, procedure when you will need to execute a document abroad, then to go to the embassy of Azerbaijan Republic in these countries. Well, Ilhama, yes, right. I'm really sorry for that. It's a Ministry of Tax liquidated, but they still call it the Ministry of Tax, but now it's kind of under the Ministry of Economy, but it's still the responsibilities lies with, now it's not called Ministry of Taxes. Also, if you will check their website, it's still Ministry of Taxes, but let's check their official name now. It's Ministry of Economy, but it's not the actual Ministry of Economy, which says, but by the way, if you go to their website, it's still Ministry of Taxes. It's a funny thing. Yes, so it will be Department of Taxes or whatever it is, how they will rename it, because it's still officially called Ministry of Taxes, which have been given to the Ministry of Economy, but they will just rename it and probably will call it either department or idare, department, İktisadiyyat Nazırlığı nazında vergiler, and something else will add to that. So yes, it's right command, but it's still, people still refer to it as a Ministry of Taxes, and because they don't have any other name so far. So yes, thank you for comment, and it's really good to see that you're following. That's nice. So yes, what's happening there is when you go to legalization procedures, if you have any documents executed, yeah, that's true. That's the official name. That's Service for Taxes, vergi hizmeti. Where you go and you submit the document. So it's a matter just of the habit, still calling it Ministry of Taxes. So yes, it's a taxes service now. So you go and register with them. So when you need to execute the documents which have been executed abroad, you need to legalize them before bringing to Azerbaijan, which will involve going to the Embassy of Azerbaijan Republic abroad, going to the Ministry of Foreign Affairs, for instance, to legalize the document, which is a burdensome procedure and might take some time, which prolongs. In order to avoid it, there is a Hague Convention, which is which provides an easier way to avoid legalization, but rather having the documents being apostilled. It's an alternative for legalization of the documents. And apostille, there's a convention, is 1964, I guess, which if any country is joining to this convention, they allow to execute the document and exchange the documents and recognize the documents executed in such countries in more simplified way if they have joined this convention. So for instance, Azerbaijan have joined this convention, let's say France have joined this convention. So if you have any document executed in France, you won't need to go to the legalization procedures, but rather to through apostille procedures, which is either an apostille is usually done by the local notary public in the countries where the documents are being executed. So if you want to have any documents which will be executed by your foreign founders, which would have to be recognized in Azerbaijan, you will need to go to this public notary to execute there, to have apostille, if they allow for apostille, and then send the original documents to Azerbaijan, and then to take this document and go to the service of taxes, to tax services, and provide them and submit this application there. And you submit this application there. So therefore, it's quite important in terms of the time frame, considering the time limits you have between the execution of the document, submission of the documents, to consider this time frame that you will need probably to send the documents by express post rather than ordinary post, and so on and so forth, these factors. Another thing to mention also about the execution of the documents which are being executed abroad, it's really needed for corporate governance perspective. I mean, we have legalization procedures. We have an easiest way of legalization, which calls apostille. And beside that, there is some either like a multi-country agreement or two-sided agreements where the countries will provide even for the easiest way of recognition of documents. For instance, between the countries of between the CIS countries, there is another Minsk convention which will allow actually documents executed in your country, for instance, in Azerbaijan, between the CIS countries. If it's executed in Russian, this document will be recognized automatically in that other country with no need to translate the documents or to go through a postal procedure, simple by notary or by me executing document in Russian language. Or if it's not in Russian, then you execute the document in the original you need to have, for instance, let's say in Azerbaijan language. So the only thing you will need to do to recognize the documents in Russia, it's actually just to have a notary translation of the document from Azerbaijan to Russian, but not the legalization apostille of the documents itself. So it's much easier procedures to follow. So you always need to consider and to consult if there's any agreement in place that you need to follow in order to recognize this document in that other country. So yes, going through all these procedures, when you have done and submitted all the documents and they're in due order, they will be quite easily to register them from commercial legal entities. But the only thing that, just reading the comments sometimes. So yes, thank you for your note. And yeah, that's a tax service, but it's doing the same function as Minister of Taxes. So again, if you go to, it's about registration. Registration is quite, again, as I told you, for commercial legal entities, is quite simplified and easygoing procedures, and you will rarely face any difficulties on that. The other things to consider that with registration of legal entities, it's not something like a standstill, that you have registered one and then you can do whatever you want to do, and you never need to go back to the tax service to amend any documents or to any other services for that. No. Any amendment to the registration details initially provided will need to be registered. So for instance, if you have indicated the name of one of the founder, and then one of your founders send their shares or send the interest in the company to another person, there's actually change of the founder, which is now a shareholder or stakeholder or interest holder, you will need to go and register it again, because the amendments will come into force only from the moment of their state registration. Until that time, there's actually not. They're not in force. This relates also to increase of the charter capital, to decrease of the charter capital, to change of the legal address of the company that you will need also to register. So you might consider this always and bear in mind that. And you usually have around 40 days, and it's 40 business days, from the date of execution to go and submit for registration any change in the registration details or any change in the registration documents. And if you don't follow this time frame, there's a penalties determined under the Administrative Code of Azerbaijan in terms of not registering in time. So you also need to consider that you need to do it within certain time frame to register. And when I talk about the registration of legal entities, as you know, registering, it's not always that you register new legal entities. Sometimes registration of legal entity happens due to its reorganization. If you will follow the Civil Code of Azerbaijan Republic, in a particular Article 55, which talks about which talks about the reorganization of legal entities. So actually, you may create legal entity by reorganization. It either going to connecting, merging, in other way, actually demerging of the legal entities, or change of the form. For instance, you're changing legal entity from closed joint stock company to open joint stock company, or from limited liability company to joint stock company. There's actually some limitation that you can form in terms of changing of the form of the structure. There's some form that you cannot change from one form to another. So you need to go and consult and to consider these limitations. But otherwise, if you will go to, you will see there's a birleşme, koşulma, bölünme, ayrılma ve çevrilme. It's also kind of a basis for having a new legal entity. But in comparison, what makes a difference usually reorganization, creating legal entity in terms of reorganization rather than establishing a new illegal entity. The difference here will be when you doing a new legal entity, there's actually no history behind. So it's kind of from white list. Whilst when you're having a reorganized it's not a new legal entity, it's coming in a different form, but actually bringing all the history with itself. So as if any rights, obligations, if any property, it will follow to the newly reorganized entity. It's actually, but if it's in division, it's otherwise. They will be divided, and part of the rights and obligation will go to one entity, and parts of rights of obligation will go to another entity. So it's just matter of just some consider in terms of how the rights and obligations will go, and if it's a new entity or reorganized entity. What else in terms of registering legal entity? Yes, you need to pay the state fee for registering of the legal entity, and also pay charter capital. And as I told you before, for limited liability companies, there is no minimum charter capital amount, and it can be as low as, I don't know, 50 cents or 1 manat, or whatever else in amount, or as high as millions or whatever. So there's no limitation on that. But just usually, again, representatives as a tax service will ask you to have at least 10 ASEAN. And quite often in Azerbaijan, if you'll go and even look to the electronic register of legal entities, you're going to find that a lot of companies in Azerbaijan has just have charter capital in the amount of 10 ASEAN. Because there's no limitations, obviously. But for the joint stock company, there's a minimum amount, and also it depends on what types of joint stock company and fund functions they're going to do, in terms of there's a different requirements towards banks, towards non-banking financial institutions, towards insurance companies. So it depends on what type of joint stock company you want to establish, what will be the varying functions. This might be different. What else in terms of registration of legal entities? Yes, you need to have a legal representatives. Yeah, so there is nothing else. Any questions in terms of registration of legal entities? Or any notes otherwise that you will think we might add to that? No. I see none, because if there will be no questions, we'll be continuing with liquidation of legal entities, which is a more difficult procedure. That's why I'm telling you, it's quite easier to register a legal entity, but it's more difficult to liquidate it. And it's not something done within 2 days. I can say this one will be 1 month, but you're going to be lucky if you will be completing it within 1 month. In average, it takes 3 months, 3 to 6, depending on what type of legal entity, depending on whether it has some activities or not. Because sometimes people are registering legal entities, but just, to keep them there, to have them. But this entity really doesn't do anything, and it's nil during the whole time of its existence. And maybe after 3 or 4 years, the person think like, no, I don't need it, I'm going to liquidate it. So basically there was nothing done. It will be really easier to liquidate this type of entity, because basically it's just like zero operating. But if there have been some background in terms of what you've done and so on, then yeah, it will be more time demanding procedure to liquidate it. So if there's no questions in terms of registration of legal entities, then we'll just move on to liquidation of legal entities. But before we're going to that, just wanted to know not one more thing about registration of legal entities. It's about, let's say, shareholders agreement. I guess I've already noted it, but just wanted to stress it once more. Shareholders agreement is some institute in law, let's say, which is quite spread worldwide in terms of when there's more than one founder, and they want to make clear how they want to divide functions and so on. They would conclude the shareholders agreement, and quite often shareholders agreement is regulated under English law. In Azerbaijan, we have such things called in civil code, as well as in the law about state registration, state register of legal entities, such thing as called tesisçiler arasında mugavele, founders agreement. It might be mistakenly taken as a shareholder agreement, and quite often I've seen like different consulting firms saying it's the same. Yes, the founders agreement is also directed towards regulating rights and obligations between the founders, how they plan to manage the company, how they want to distribute dividends or profit, or what they're going to do. But it's quite basic documents, and it's not exactly the shareholders agreement institution, let's call it, how it's seen from English law perspective. Because shareholders agreement you have under English law, it's the document that will give you a lot of possibilities to work and to see and manage the company differently. Unfortunately, Azerbaijani law does not provide you for such opportunities. That's why if you, for instance, if you're working in a company that provide consultants, and you have, let's say, foreign legal entity which wants to come and have a, let's say, joint company in Azerbaijan with some local investor, and he says, I want to have a shareholder agreement, and you will say, yeah, we have it, and it's a founders agreement. No. This is not the same, because, for instance, it might consider having drag-along or tag-along rights in a shareholders agreement, or this foreign founder or foreign investor might want to have a different distribution of dividends. For instance, in Azerbaijan, you receive a dividends which is proportionate to your investment in the company. So if you have your partner, for instance, you provided 50% of the chartered capital, and the other partner provides 50% of the chartered capital, your dividends will be distributed 50-50. So according to your proportionate interest. Or if you have 45 and the partner 55, it will be 45-55. So you cannot actually amend this ratio. Whilst, for instance, under English law, they allow you to do it differently. You might have 50-50, but at the end it divides the dividends 1-99%. So it's quite normal for them, because they might say, okay, you bring expertise, not only money, and that's why you actually get you're going to get more money out of this entity, of the joint entity or joint vehicle, rather than I do. So there's a lot of these types of institutions that you can do in a shareholders agreement, or, for instance, provide provision for increase of charter of the company without actually increase of the charter capital. This is also something different, which is not allowed in Azerbaijan. It actually has been allowed in Russia starting from 2015, but still not in Azerbaijan. If you wanted to provide financing, being a shareholder, you need either to provide some sort of loan, it's either equity or debt financing. So equity financing in Azerbaijan is just increasing the charter capital of the company. And for that, you need to go and register increase of the charter capital. or provide loan financing, debt financing. It can be some obligations, it might be loan, but there's no other way of equity financing. Whilst in English law and currently in most of the countries, not most of it, but in some of the business world, let's say, countries, they allow you actually to provide equity financing without increase of the charter capital. So it's just like some amount of money you give to your company and then you can get back or leave it there. It's not considered to be loan financing, and it's not a charter capital increase. For instance, and it will not be allowed to do it in a shareholder or a founders agreement in Azerbaijan. So although, yes, in Azerbaijan, you founders agreement, if you have any founders agreement, you provide it along with registration documents. But when it's a shareholders agreement abroad, no, there is no. For instance, in English law and in England, you don't need to register shareholders agreement. That's actually another thing why some partners prefer having a shareholders agreement rather than putting everything in a charter. Because when you have it in a charter, charter is a document you're registering, while the shareholder is agreement that you're not registering, and you can put some confidentiality matter there that you don't want to disclose to other parties. So it's another thing that usually provides the institutes of the shareholders agreement. Thank you for question. So yes, you might need to consider these differences. Again, as I noted in the previous class, that there's some concepts in terms of the name which coincide in Azerbaijani law and the foreign law, in particular in English law, New York law, some like other international law, commercial law, which you use as a basis, let's say, for a lot of international agreements, international commercial agreements. But when you go to see their essence, you might see it's different, or the Azerbaijani one not providing enough rights as you might think. So yes, this was a thing I wanted to note about the registration of legal entities. And now moving to liquidation. Any questions? I see none. And if there's no question, then we might continue with liquidation of the entities. Liquidation of the entities is quite widely described in the civil code of Azerbaijan and the procedures you need to follow. Again, it's the same with the registration of the legal entity. It starts with the application that you will provide to, again, tax service under auspices of the Ministry of Economy of Azerbaijan, wherein you will be able to state that, yes, I wanted to liquidate the legal entity. And for that, it's not just a mere application. You need to have a resolution of the shareholder of or if there's just sole shareholder. If it's not sole shareholder, and you have several, then it should be like a general assembly, general meeting of shareholders, or general meeting of interest holders, and so on, where they will take a decision to liquidate the legal entity along with yes. And also, you need to have also a resolution on appointment of the liquidators. You can appoint the director, who is your current director, to be the liquidator of the entity. It can be just one person, or it can be liquidating committee. It's also for the shareholders to decide how they want to proceed with liquidation of the legal entity. But once decided, they need to put it. And the other thing, once you register these documents with a tax service, this is actually will becoming binding, and director will have no longer right to exact documents on behalf of the company. It will be actually liquidator, and it will be called the liquidator or liquidating committee, who will be exacting the documents on behalf of the company. So when you go to register to start the liquidation process, you provide application, resolution of the general meeting, also resolution on appointment of the liquidator of the liquidating company. It can be also like combined and having a one document, or you can do it in two separate documents. So it's up to you to decide. You also can put date from which you want to start liquidation process. Let's say you can exact it today and say the liquidating from, I don't know, this date. So it's not necessarily from the date of execution. If you don't have any date in your document, then it's by default will be the document when you start your liquidation process, or you submit the documents to the tax service. There's also time frame in terms of when you need to submit the documents to the tax office to the tax service when you decide to liquidate the legal entity. And if you didn't manage to provide the document within the time frame, you will need to start the process anew. So it's not that you can execute the document and wait for 2 months and they say, okay, I will go and submit. No, this document will no longer will be effective, and you will need to have a new one to start the process. In terms of liquidation, what else you need to have there? And when you go at initial stage, actually during the liquidation process, you will need to go to tax service and to some others like state authorities several times. So it's not just like a one-time process as you're doing during the registration. You go just once, submit the document, then wait, and you receive electronic notification of registration, and then just go and collect your documents if it's not electronic one. If it's electronic, then you're doing everything electronically. With a liquidation, you might need to go several times, because at the first stage you besides the application resolution, you also need to submit the stamp of the legal entity. And the stamp, when you submit the old one, you will need to go and get a new one, which will have written in the stamp itself that its legal entity is in the process of liquidation. Once you have met it successfully as a first stage, this package of the documents, which is a resolution, application, your stamp, decision and appointment of the liquidating committee, and so on. And if it's not liquidation due to the bankruptcy, because in a bankruptcy you have a different procedures, and I think for the bankruptcy we'll having a separate class because we need to have more details on that. Yes, so once you submit this whole package of the documents, the tax service has 5 days to check whether you have provided all the documents required, and if yes, they start the liquidation process and they send you a notice of starting liquidation process. Once the liquidation process has started, then within 30 days, they will should start and appoint a tax auditor, because when you start the liquidation process, they need to check and make sure that actually during this time of your functioning that you have properly functioned, because during your period of working, they might have an audit or not. So it's just like not that it's must that you will have the audit, tax audit, any other audit once a year, once in 2 years. No, there's no such things. But when you're going through liquidation process, it's a must. Tax authorities, in this case, tax service, will check whether you have complied with your tax obligations. So they're going to appoint you tax authority. And the other thing that if you have any overpaid taxes in your account, or because when you have overpaid taxes, or you, let's say some amount of money in your VAT account, it's also was a tax service. Sorry, I still keep saying Minister of Taxes because it just like we've been calling it for the past 10 years and just need to change it to the tax service or tax authority at least. So yes, once you have, they're gonna appoint the auditor. An auditor will come and check your tax record either from the date of the last audit or the last 3 years. 3 years kind of a statute of limitation unless there's some serious concern and serious reason for, to go back. But basically it's 3 years of your functioning, that's the last 3 years before the liquidation, that they will start looking to and to see if you have complied, whether you have timely filed or your tax returns, if there have been no tax evasion. And at the end, and that is something on practice, that's a process that takes the longest in the liquidation process. Because the other thing that you have in this liquidation process, you need to provide the letter from the court that there's actually haven't been any cases against you and you have no pending court litigations, because without this letter, this actually is also some novelty in legislation. Before, like I guess 4 years ago, you didn't have this requirement. It has been introduced like relatively recently that you also need to provide the letter from the court to the tax service stating that actually you don't have any pending court litigation. So this is an easiest one. The only thing that's in the liquidation process, which is time-consuming and more effort-consuming, it's a tax audit. They will need to check, they will come to the office, or they will ask you to send the documents, they will review them, they might ask you for additional. And this is the thing, if you have any overpaid tax in the balance, that's what I was talking about, a VAT and your VAT account, it will take quite long, because it's not that you just don't want, it's a matter of practice, not only in Azerbaijan, but quite a lot of places. They don't want to return the money back. So it's kind of, they find some mistakes in filing, or say you have too much deductibles and you shouldn't have deducted this cost, for instance. Or for instance, I have seen ones that when we had an overpaid tax of around, not we, but our clients, of around 10,000 ASEAN, and they wanted it back, obviously, and tax authority didn't want to get it back. What's happening is that they say, okay, provide me with a list of your telephone calls, mobile, for instance. Let's say you have a business phone that you're doing phone calls from time to time, and they say, okay, give me extract or something like paper with all your telephone calls where you have been calling in the past, I don't know, 1 year, 2 years. You can go and take it from other cell, Baxel, or whatever, it's like your phone provider, business phone provider. And they're gonna check one by one, like whether it was business call or non-business call, or maybe you have been calling your father from your business phone, right? And you have put this as, you haven't separated it from your business calls, and actually you have deducted this expense from your profit. So it's something you shouldn't have been done. So they start reviewing even such things. That's my point to you. So in order not to get money back, and they say like, okay, this one, you need to have paid it, you have need to consider it, it's not your business call, it's your personal call, you have divided it. It's just one example. And there's might be some other things or some other spendings and events. They would say, no, it's not a business need, you shouldn't have done it, and so on. So yeah, but at the end of the tax audit, they need to provide you with a letter stating that we have conducted a tax audit. There's no concern from our side, and we're okay. We've been clear. It's once you have completed, once you have finished it, and after going through all the processes. Usually, at least from my practice, I can say that if it's been like a normally properly operating company in the past years, it will take around 3 months to go through the tax audit from beginning till the end, up until receiving the final notice, final letter from them stating then that you have no dues to tax authorities, or if you have dues, but you have paid them at the end of the tax audit, so stating this letter, which then you will, they usually send automatically to the tax service, because within the tax service, they have separate departments, right? And separate divisions. And there's the division responsible for tax audit is different from the ones responsible for registration of legal entities. So one department will say not to another department, stating, okay, this entity has been cleared and you can proceed. But the other things to mention that the tax audit is not the only audit conducted by the state authorities during the liquidation. You also need to obtain the letter from state authority on social protection of population, on labor and state social protection of population, which also should state that you have paid all dues on the employees, because you pay taxes not only taxes, but you also need to pay social contributions from the salaries paid to employees based on. And this goes to state social protection of population. And they also need to provide you with a letter stating that you have no dues to this state authority, and you can proceed with liquidation. This is something you can do in parallel to the tax audit, but it's relatively easier and less time consuming than the tax audit. What else you need to do during the liquidation process? Of course, you also need to, if you have any employees, you need to terminate the employment contract. It's also quite often you're being asked as a lawyer. You can be as a consultant lawyer, you can be in-house lawyer. It depends on you, how you're going to work. So both are way. Quite often you're being asked by the employer or client, what's the exact date when you need to terminate employment contract? Should we do it prior to start of the liquidation process? Should we do it during the liquidation process? And if it's within the liquidation process, when is the exact moment when you should do it? Just a quick question. I'm not sure about it. I think like a 45 minutes of our lectures being elapsed. Do you also do break during the online sessions as a normal class, like a 5-minute breaks, or you want to continue? It will be good to have your inputs on that. So 5-minute breaks or no? Is there still anyone listening? Anyone? So I think I'm comment from Nargiz that to continue without the break. If everyone is also okay. Okay, good. So let's continue without a break, and then probably we'll just finish earlier rather than having an hour and a half. I guess we just will finish today with liquidation of the entities, but we'll see if we want to cover anything else using today or just have to another class. So yes, when you do liquidation, so it's quite the question you always get as a lawyer, irrespective of whether you're in-house lawyer or whether you are consultant providing advice. This is quite a puzzling question, when we need to terminate the employment contract, because at some point in the liquidation process, you need to prepare the balance sheet with all the rights and liabilities. So in such case, what will be happening is that there's no clear answer to that. The only clear answer, yes, if you wanted to terminate employment contracts due to the reason of liquidating entity, then you need to do it during the process of liquidation. Because if you know the labor code, there's have a different articles which allow you to terminate the employment contract. And one of the reasons that's specifically stated there is liquidation of entity. I just want to take this, its article should be 70. Let's just quickly check it, so I'm not providing you with any misinformation, but I think it was either Article 69 or 70, which were stating the basis of terminating of legal entity of employment contracts. So if you want to refer to this particular basis for terminating employment contracts, you need to start the liquidation process. And by the start of the liquidation process, it's not just having a resolution of the shareholder or of the general meeting of shareholders, but it's actually going on registration of your application by the tax service. Only after that you can terminate employment contract on this basis. Without it, you can't do it. So it goes with with Article 68. There's Article 68, which was say what are the bases for termination, and there's Article 70, yes, which says based on the employer's basis to liquidate. 70A, it's in case of entity being liquidated, which provide you basis to liquidate the employment contract. Okay, that's just a question. Nargiz, I will just complete on liquidation and we'll get back to your question. So yes, when you have a terminate employment contract, why it's important to see, because there's always, because sometimes, as I noted during the liquidation process, you're going under various audits. And in order to go through this audit, you need to have some employees which will be able to answer their questions or still have the company operating up at a certain point. So it's not empty during the liquidation process. That's why it's a question that's always being asked, okay, when we need to terminate, or when's the last moment when we can terminate the employment contract, you know? And as I noted, there's no clear defined answer. The only thing, it's not up until the start of the liquidation process. Once you have liquidation process started, it can be at any time during it, but quite often, and from the practice, I would say the termination happens at the time when you prepare the initial l'arrêtement balancé, which is not yet final, because the final one you provide at the last stage of the liquidation process when you have completed everything. Because preliminary, we divide liquidation process 3 stages. First stage is a application stage, when you actually go and submit the document to start the liquidation process, prepare resolutions, and so on. So it's the first stage which is usually being completed by getting notification from the tax service which says your application has been accepted for liquidation. So it's actually when you have this liquidate first stage completed. The second stage is when this all audits happening. So when you have this all audit completed, this is your second stage. You go to tax auditor, tax audit, state social protection fund audit. You go to the court to obtain the letter stating that you have no dues, and you do all other things. You do the final payments with your employees and so on. And the third stage is when actually you've completed with all the audit and with all the payments due to your debtors, or your creditors, receivables, and so on. You provide the final package of the documents again to the tax service, and when it's done, it's only when the company will be deemed liquidated. But again, this is preliminary division of liquidation stage. There is no such things at liquidation stage in the legislation. It just for the ease how it's divided and for the better understanding, but actually it's not a legislation division of stage of liquidation, okay? So usually the termination of employment contracts happen at the second stage. So nobody will wait till the end. Why? Because you need to provide the liquidation balance sheet of the entity at the end of the second stage. And to be able to do that, you need to have all the dues paid. And you will not be able to pay all the dues if you haven't terminated employment contract with your employees and you haven't paid their salaries. So some of the employers will pay something in advance. So after termination of the employment contract, the person can still bill with the company and complete the liquidation process or get some remuneration for that. So this is some troublesome moment of the liquidation when you need to terminate the liquidation company. So in terms of the question, if auditor is dissatisfied with the activity of company during the last years, is it an obstacle for the liquidation? So what's happened here? It's not a tax auditor is dissatisfied or satisfied. It needs to provide you with some findings, stating that either you have failed to submit, for instance, some tax report, or you have hidden some profit, or you have paid some taxes which you haven't paid. If you agree with that findings, you go and pay this tax dues to, again, tax service, to tax authorities, and once you have paid, you're done. If you don't agree with this decision, or that yes, it is until it's cleared, it is impediment for you to complete the liquidation process. So if you disagree with the decision of the tax auditor, for instance, it says you need to pay X amount of taxes, and you say I shouldn't do it, you can appeal on this decision of the tax auditor. First, you appeal within the tax authority itself, within tax service, or maybe now it's probably within the Ministry of Economy that you can also appeal the decision of the tax auditor. So you will appeal on that decision. If the tax service, the higher body, which is not the tax auditors have conducted audit, but another like higher department or higher division or ministry, it's the ministry itself, there's an appeal committee actually. If they agree with you, they can dismiss decision of the tax auditor. Then again, you can go to continue with your liquidation. If they also think the tax auditor is actually right, the other recourse you have is to go to the court. And then you will need to have the court proceeding to be able to prove that you're right. But until you have been cleared from tax in terms of whether you're right and actually there shouldn't have been any tax dues, or no, tax auditor is not right and you need to pay taxes, until it's finally been cleared, you will not be able to proceed with liquidation. That's actually the truth. So either you'll be able to prove that you're right and you have no dues, or you will pay the taxes. So one of the two. So you can appeal to the higher body within tax authorities, tax service, or go to the court, obviously. But the other things to consider during the liquidation process, I was planning to tell towards the end, but as we have come to the point of appealing, you need to consider that the whole liquidation process, as per, again, relatively recent amendment to the civil code, you will need to complete the whole liquidation process within 1 year from its start date. So if you haven't completed the liquidation process within 1 year, let's say you have starting, I mean, you went the tax service submitted the documents, they have accepted it, and you have received notification of start of the liquidation process. So from that date, you have 1 year to complete your liquidation. So if by 24th March 2021, you haven't completed your audit because of, I don't know, any disputes you have with tax authorities, any court litigation pending, it means that liquidation is not completed, your time is expired, and you will need to start it over again, the whole process. So that's why people are quite often, when thinking of whether they need to question any position, whether they will be able to complete the tax audit within 1 year. Actually, once in my practice, I have seen the case when we managed to complete just within 11 months. So we're literally having just 1 month left. And it was exactly because we were arguing with tax authorities whether we have any dues or not. That was the case, and we were, appealing the decision and so on. But at the end, we managed to find a solution. But it took us like around 11 months to complete the liquidation process. So yes, I hope I answered your question. It needs to be cleared. It's not that they disagree, you ignore this decision, and you continue with liquidation. No, you either need to dispute it, to argue it, and to prove your situation, or pay this tax or agree with them. Otherwise, you will not be able to proceed with the liquidation. So yeah, and for the state social protection, I can explain you it's relatively easier if you have paid all the dues to your employees. And for termination of the employment contract, as I told you, it's another things to consider, and also to consider when maybe you don't need to keep all the employees for the whole duration of the liquidation process. So actually, you can already start terminating once you have completed, with submission of the documents. Or you maybe want to keep everyone till the end of the process. But usually will happen that the company will keep 1 or 2 key employees to complete the liquidation process, and the others will be terminating from the date you started, you have registered your liquidation process starting. Another thing to consider during the liquidation, even before going about submitting l'arrêtement balance, it's about submission of notice to the official newspaper about liquidation of the company. Why it's important? Because obviously, if you've made a decision of the general meeting, or you have a shareholder resolution about liquidation of the company, your creditors, third parties, might not be aware of it. So they might think that you're functioning, or maybe you have any dues for them, because how do they know that you actually started the process? Of course, if you're a good person, that's a good entity, or like you have a good corporate governance standard, of course you will be informing your creditors that you have started the liquidation process. So if they have any claim towards you, they have time to submit a claim, either to you or to court if you're not agreeing with the payment and so on, but to be able, to handle the situation. But not everyone has a good corporate governance practice, or someone might, why I need to tell them. It's better if I close it and I don't pay anything to them. To avoid such situation, there's actually such a requirement in terms of, let's say, about publishing in the newspaper, an official newspaper, of the notice about liquidation. So before, thank you for commenting. We're still continuing, so but it's a pleasure for me to have this class. So yes, when you're doing it, you need to publish a notice in the newspaper. Before, you only needed to do it once or repeat it twice. Now, within a 60 days period, you should be able to publish 3 times notice on liquidation in the newspaper. It can be, there's an official newspaper of the tax service, which calls Vergiler Gazette. It can be notice, and that's actually what the companies will do. They usually will publish the announcement on liquidation on this website, on this newspaper. Sorry, not website, on this newspaper. So, and actually, first notice, you need to bring the first notice on liquidation already with the initial package of the documents you submit to the tax service. So if you have together with the resolution of the shareholders of the general meeting on liquidation of the entity, you also bring the notice on start of the liquidation process that you submitted to any official newspaper. Usually in practice, Vergiler Gazete, but it can be any other official newspaper or publishing where you will have this, announcement. And within this announcement, you provide a time frame within which the creditors must submit their claims. There's no maximum period, but obviously you need to have it less than 1 year, because within 1 year you need to complete the whole process, but you need to provide at least 60 days to them. And this actually this minimum time, which would be the time the companies usually adhere to, and they don't, think of other matters. They will just, go with 60 days rather than having more time. So within 60 days, the claimants need to submit any possible claims they might have against you. If they haven't done within this period and they don't have an official excuse for that, then it means that they will not have any other opportunity to submit their claim for you. And, once you have completed with your liquidation, they will not be able to tell you, oh, sorry, I didn't know, and, claim their request. It's a official time frames they have it. So once you have done with this announcement, and once actually this time has passed, so if you have like 60 days elapsed, there's no claims or there's a claims, you prepare this liquidation l'arrêtement balance, but it will be preliminary liquidation balance, because at the end you still will need to have submit the final liquidation balance sheet, which will be at the end of the whole process, where you will have all the claims. If you have anything any outstanding, why it's important to have this l'arrêtement balance, so liquidation balance sheet, it's because you will be able to show all your dues or all receivables, all amounts that you have as a debt or as a receivable in your account, whether you need to pay anything to claimants, and what you're going to do with any amount left on your balance. Because sometimes when the company is liquidating, it might be having a not zero, for instance, account, but for instance, having certain amount of money. Let's say you have a 20,000 at the end left on your account. What are you going to do with that? You might need to distribute this as a share to your shareholders, for instance, or you might give it to charity or do whatever it is. But you will need to show in this l'arrêtement balance if there's any outstanding amount and what are you doing with that, or what you have done with that. At the end of the day, when you submit your final account to tax authorities for the completion of the liquidation process, you will need to have a zero. So, which is like a zero debts, zero claims. So yes, basically this happens at the liquidation. It's the main stage of the liquidation. Once you have done with all the audits, thanks Firaman for noticing, but I think I'm wrapping up our discussion on liquidation. Thereon we'll having probably assignment, and I will send you assignment by email. So once you have completed the whole process with liquidation, you will need again go to tax service, submit all these letters you have received from the tax authorities, from the court stating that you have no pending court litigation, from the State Social Protection Fund stating that you have no use to them. We call them SSPF. Then you will need also to submit the originals of your charter documents. That's also something that you're not keeping with yourself, that you need to return to the tax office. And if you have lost it, and it happens actually quite sometimes that you have lost some documents, which were your original registration documents, you will need to provide the announcement in the newspaper that you have lost this document. And instead of providing this document to the tax service at the last stage, you need to provide the announcement that you have lost actually this document. Yes, it's burdensome, but it's a reality we have. So yeah, once you have submitted the whole package again of the documents, and you need to check, there might be some additional actual documents, but for the details, again, go with either to the civil code or to the law on registration register of state legal entities, where you will find out all the information you need to submit it. Once you have it, if again, like 5 business days, if there's nothing and if the documents are accepted, you will receive official notification from the tax service stating that the company is now being liquidated. And from that moment, only from the moment of receipt of this notification, the company will be deemed liquidated, not at any time before. At the any time before, it's just in the process of liquidation. Okay, and also you don't forget you get stamp for that you use for stamping the document that you're in the process of the liquidation. So I think this is basically it on liquidation. Do you have any questions on liquidation process? Let me check, but I think we've kind of covered main points of it. But no. Yeah, nothing just to mention. The only thing that to mention that if there's a balance of amounts to be paid to the creditors, it's not enough on your balance. If you don't have enough amount to pay for your creditors, then you will need to follow the bankruptcy procedures to liquidate the company rather than, following the ordinary way. Yes, this is it for today. I think I just wanted to cover it with you change of registration details, registration and liquidation of legal entities to make sure we're on the same page. There's some differences between limited liability companies and joint stock companies in terms of of registration or liquidation or the purpose of it. This actually will be your assignment for next class, and I think I will send you the details with some information. And based on that, I will be expecting to receive your input. What will be recommendation form to compare the registration, or not only but compare limited liability company to joint stock company, and to provide an advice what would be the form you're advising to your client, your employer, or to your friend, or whoever is else referring to you to establish a legal entity in Azerbaijan, in which forms. Okay, I think this is it from my side. Any questions on today's topics or on how we're going to work in the next, I don't know, couple of weeks? Well, no, but it depends from differs from country to country. But I would say liquidation process in all of the countries is more difficult than registration process, because in all of these countries you might need to have the audits, state audits. Sometimes they will skip it, but sometimes they will have it. But it's definitely more lengthy than registration process. Not 1 year, but it can take couple of weeks or couple of months, but usually like up to 3 months, not longer. But in Azerbaijan, I have faced sometimes 6 months or so on. Again, it depends on operation of the company. But there's no specific time frame that I would say like in that country it's like within 1 week. No, it's all like case by case basis. And for instance, we have recently liquidated one of the companies in Italy, and I think it took from October to January. So we've completed with liquidation just in January. So it was around 3 to 4 months to complete to liquidate the company. But again, it can be much lower. It can be like 2-3 weeks. It have been cases as well for liquidating abroad a legal entity. If there's no more questions, again, thank you for joining live stream. Hopefully you get some insights and some useful information. I will try to send you some advanced information for the next class, besides having a homework to compare LLC to joint stock company. Some cases probably that we can have a more interactive discussions. Maybe we'll see how it works and if it works at all. So it's not only me talking, but also having your inputs, or at least discussing some real case scenarios. So yes, stay safe. If you have any questions, email me, and I will also keep in touch. Bye, and thank you for your attention.